Like we said, we've got some new features and teams, and we didn't have any coaching in how to use them. So we're just hitting buttons and seeing what happens. But good morning. Welcome to this January 28th session of our Kentucky Lead Saturday seminar. We're happy everyone could be here. As a few reminders as we get started, to be mindful of your mic. Just remember that if you want to be muted, you are muted, and if you want to be unmuted, that you hit that unmute button. Just a reminder to keep your video on as much as possible. We understand that some of you may not have great internet or you may have things going on in the background, but we do ask that if you're speaking to turn it on. And if you can, again, if you're not having connectivity issues. This is a recorded session. We keep these sessions recorded so they can be posted for later viewing. And then just as a reminder, if you need a break, feel free to take a break. If you need to step away for a second, just let us know in the chat that you've stepped away for a second and let us know when you've come back. Navigating teams, I feel like maybe I should just ignore this whole slide because there's all new buttons this morning if you have an update like I do. But essentially what you need to know, camera is this button, mic is this button, chat room is this button here that says chat. Those are the ones you probably want to know and care about the most. And I don't think those changed. Just a reminder of our norms to participate respectfully and welcome the multiple viewpoints that we hear from all of our scholars. Devote your attention to those speaking and sharing. As I always say to others, be there or be here. If you need to be, if you have to be somewhere else, then that's fine. You need to be there. But while you're here, please be here. Ask questions for clarification. You can use either the chat feature or the raise your hand feature if you have a question that needs some clarification. Be courageous and speak your truth, but also own your intentions and your impacts of what you're speaking and sharing. And importantly, to remember and honor our time together. A few ways you can stay connected to Kentucky Leads. Again, just as a reminder, you can use our SharePoint site. Everything Kentucky Leads is posted within our SharePoint site. There is a directory, so if you have a question that you would like to chat with someone maybe off of this session, maybe someone had a great idea or a thought and you want to share that, you can go to our directory and see their personal email or their work email, I should say. And of course, there's our Kentucky Leads discussion board where you can pose questions, ideas, thoughts, or even just share something really exciting or good. So if something really cool is happening in your district and you just want to share, that's a great place to put it. If you have a question about maybe a new resource, you're looking for new ideas. Again, those are some of the great things I've seen happening in our discussion board so far. So please continue to keep that up. As a reminder, in case you missed it, our December session was on grant writing and maintenance of effort. A lot of great discussion happened during that December session, so thank you to everyone who participated. You can go to our SharePoint site and get a link to that session, or once this PowerPoint is sent out afterwards, you'll also be able to link everything from here. Our agenda for today looks something like this. We have a quick check-in. We'll have a few updates. Today, we get to hear about notable special education court decisions and other important authority. We get to hear from David Wickersham. It's going to be amazing and awesome. You guys are going to love it. We'll have a break, and then we'll get to hear from David some more. We're going to have small group discussions afterwards, a bit of time for group sharing, and of course, our evaluation and our wrap-up. And just as a little side note, this break time may change. We're going to kind of just see how conversation is going. I know last week we had such good conversation with Jonathan that the break time kind of changed by a few minutes. So keep in mind that this is tentative and it may change by a few minutes. Mike, you have some updates and reminders for us, I believe.
Indeed. Thank you, Shasta. Hey, everybody, this is an important date. I'd like you all to please write down June 10th. And what this is this is going to be our summit, our Kentucky Leads Summit. We had one last year. It'll be in Louisville, and it'll be in the Downtown Embassy Suites Hotel. And what this is a gathering of we have national speakers as well as state speakers, focusing on all things that are going to be pertinent to you in a future director of special education role. We'll cover the costs for that, your travel, per diem, hotel room, etc. So we'd like to we're really encouraging everyone to do everything they can to please attend. I felt it was a very powerful summit last year. We'll have on the Friday before, we'll have a little meet and greet in the evening there at the hotel like we did last year. And then on the Saturday, we'll have an all-day session. Probably wrap up. We haven't firmed up the agenda, but probably wrap up around 4 o'clock-ish like it did last year. So June 10th, Embassy Suites Hotel in downtown Louisville. Please make a note of that. And a couple of little things here. If you do miss a session for some reason, there's a form. If you would please fill that form out. It's just we ask you to review the video recording and then fill the form out. Send that to myself and Rebecca. That would be really helpful so we can keep track of that. And those are my, last one, we'll be reaching out to cohort 2 in the spring here, talking with you about our leadership skills checklist. This is something we do for our evaluation for the project. So it's an important piece for us just to track kind of your progress. So we'll be reaching out to cohort 2 with more information about that in quickly approaching spring. Thank you so much.
And I just want to put in a little reminder here. If you have moved recently, we do have a link here for you to update your mailing address. We always try to keep those things, keep on top of those things that if we do need to send you things. So if you could just please make sure that your mailing address is always accurate for us, and you can use this link to get there. Are there any questions before we move into our presentation? And I cannot see the chat any longer because of the shift in my screen. So if there's something in the chat, if Becca or Bill, Mike, if one of you could let me know.
There are several positive comments about the summit. Thank you. But I don't see any questions at the moment, Shasta.
Great. All right, I'm going to hand it over to David Wickersham. He works with us. We're very fortunate to have him in the Office of Special Education and Early Learning. So if David, if you'll just give us like a little brief info about yourself, and then we are going to jump into this this presentation, this conversation around notable special education court decisions and other important authority. David, please take the screen.
I'll try here. Somebody let me know if it doesn't work. I can see it. Is it visible to all of you?
Yes.
Okay, great. So, well, I guess first of all, thank you for inviting me and giving me the opportunity to talk to you a little bit. My current role at the department, I'm a consultant in the Office of Special Education and Early Learning, and essentially provide support in IDEA interpretation and implementation, and then also do some work with our other program areas, the gifted and talented programming, extended school services, preschool, public preschool, and just kind of other initiatives that take place across the department and also take place through action of the General Assembly, but kind of trickle down into our particular program area. So I've been back with Greta Hilton, the Associate Commissioner for Special Education and Early Learning and our State Director of Special Education. Been back with her for a little over 2 years. Other roles I've had at the education, I was an Assistant General Counsel, a division director, a policy advisor, handled a few different types of things, ran the Office of Education Accountability for the General Assembly. The legislative branch has an office dedicated to the oversight of elementary and secondary education. So I was responsible for that office for 4 or 5 years around in there, and then came back to try to help Greta. I don't want to say improve, but I think just it's a continuous improvement cycle for us, just in terms of being sure that we're doing the best that we can at providing state level support that trickles down not just to schools and districts, but even to parents and families and other interested parties, help us be responsive to inquiries we get from the Office of Special Education Programs at the United States Department of Education and otherwise. I'm not, in the mode that I'm using here to present to you, I'm not able to see the chat, so I'm going to kind of count on some of our other folks who've invited me and are helping with that to let me know if I've got a question that I need to interrupt for. That said, feel free to do that. I added a slide here, kind of a summary of all the different information that we're going to be talking about. These are just the different. Essentially, it's a summary of each of the slides and what that content is going to be. But if there's one of these that appeals to you, that you have a question about as we go, please feel free to raise your hand to get somebody's attention so we can talk through that a little bit. Because it's not going to be a problem for us to break away for a little bit of conversation around those kind of as we go through this. The disclaimer, of course, that I always have to give everybody is, put my lawyer hat on for a second. I've heard it bluntly said before, I'm a lawyer, but I'm not your lawyer. Which may not be the nicest way to say that, but the way to think about it is, I'm going to be presenting a lot of detailed legal information, try to give you some insight into the way the courts process and review both legislative action and also action by districts and even by parents, as well as by individuals, directors of special education, things like that. But what I am not able to do, either through this presentation or in my role at the department, and frankly, no lawyer at the department can do this, is give you legal advice. So I can give you information. I may be able to give you some sense of what the factors are that courts seem to weigh most heavily, but I'm not going to be able to, if presented with a set of facts, say, hey, here's what you ought to do, or here's what you ought not to do. But we can kind of talk through stuff like that, and I may be able to give you some level of response, even if I can't exactly give you advice on how to handle that. So the ones that we're gonna get through today got kind of a broad range of topics here that I kind of picked, hoping that these may be representative of either issues that have bubbled up in the districts in which you currently serve, or things that may kind of bubble up over the course of your career as you move forward and take on other and new roles and responsibilities. So we're going to be talking about IEP implementation, specifically at the Craft Academy, but think of this as in post-secondary institutions. The obligation to provide a free, appropriate public education towards students who do not cooperate, don't want to be there, don't want to be following along. Child find responsibilities, a little bit about the state complaint proceeding that the IDEA provides for. A little bit about virtual schools and a Dear Colleague letter that the United States Department of Education issued around that. Remedies for students who are, I've called it mistreated. These are pretty bad facts, but actually even abused inside a school setting. Dealing with parents who have some challenges of their own. The tennis tryout thing, it's essentially, that was the platform for a case talking about 504 and IDEA accommodations. Twice exceptional students responding to an individual education evaluation request, child find responsibilities for incarcerated students, and then the last is a little blurb about certification. So if everybody's comfortable, I'll go ahead and kind of jump right in here. So this first case, this is a case that is on appeal right now, is in front of the Sixth Circuit Court of Appeals. If anybody is a lawyer on here, or if this is your district, I'm not trying to talk down to anybody on this. I'm going to explain this as though this is kind of a novel approach for you. So I'm going to go through just kind of some fundamentals about how cases are structured and the nature of the court system in which these folks found themselves and why that may be relevant to you. If I talk about a case that your district is involved in, I'm not taking a side on any of these. I'm just telling you what the court did and want to mention it just to give you some sense of, hey, this really could happen to you if you're not careful. Or in some of these cases, could happen to you if you do everything right, you could still end up in a court case. So I didn't shield that part of it. You'll notice that most of these have initials identifying the children and their families. That's the habit of the courts, is to try to maintain the anonymity, particularly of the students, but even of their families a lot of times. If I'm using the names of a child, of a student, of a parent, anything like that, it's because the court did that and it's a published document that's out there in the public domain, so you could read about it in the paper. So I'm not giving up any information that would not be accessible to you, just to somebody out there walking around. So this case here is styled or called, the title of the case is Bradley versus Jefferson County Public Schools, but these folks actually sued an awful lot of people. They sued the Department of Education, the Jefferson County Public Schools, a whole lot of different folks. And the assertion in the case, that this one started off as a complaint at the Department of Education, asserting that a student with disabilities who had been accepted into and received services at the Craft Academy was entitled to a full implementation of his IEP at the Craft Academy. That didn't go the way that the parent wanted it to go at the complaint level or before the Exceptional Children's Appeal Board at the state level. Didn't go the way they wanted with due process or in the federal district court, so then ended up in front of the Sixth Circuit Court of Appeals. And the Sixth Circuit is a series of contiguous states. Kentucky is one of the ones in that Sixth Circuit. So if you ever hear anybody talk about the Sixth Circuit, that's a big deal because that's the one that really makes the rules for our part of the United States in federal court. So they didn't like what they got at the federal district court. That one was filed out in the Western District of Kentucky. So they took it up to the Sixth, asserting, well, we really think, even though we've lost this a bunch of times, we think that the IEP has to be implemented because this is a dually enrolled, was the assertion, that this is a dually enrolled child who, because JCPS allowed the child to attend Craft, JCPS should be on the hook for implementation at Craft. So that was kind of the setup on this. The Sixth Circuit, well, the Court of Appeal, this is actually the district court writing in the slides that you've got here, but this is on appeal right now. District court says it's not the way that works. That the definitions that are contained in the IDEA, in the Individuals with Disabilities Education Act, make it clear that the IDEA applies only to elementary and secondary school, but does not extend beyond that. It does not include education beyond grade 12. They talk here, and I've got some of this language on the slide. Well, there's some facets of this that are determined by state law, but the federal court says even state law, even if they get in there and kind of tinker with these definitions, they cannot impose any duty on a local school district in a secondary or a post-secondary institution. So even if the state's made rules on it, they can't go beyond that ceiling that is set by the IDEA. So they then evaluate a little bit more carefully, well, what does the IDEA say about this? They review a little bit about what's the FAPE obligation. That makes it pretty clear here. If you look at Kentucky's statutory definitions along with the IDEA, this was not intended to apply to post-secondary education. And they looked at Kentucky statutes and say the Kentucky statutes expressly indicate that Gatton, that the Craft Academy, these are post-secondary institutions. Now, they are providing high school students with some service, but they're providing a college level course of study. So that does not convert them into high schools by virtue of the fact that they've got these students participating. They take a look at some statutory language here in the Kentucky Revised Statute, that's the KRS part. And they say, if you look at the statutes that establish these programs, they're clear that these, are post-secondary institutions. They're providing opportunities for high school students through dual credit and through dual enrollment, but these are college level courses. And what that means in Kentucky, according to this case, is you do not have, there does not arise an obligation under the IDEA to make FAPE available at the Craft Academy. Okay, it looks like we've got a hand up.
It's me, it's Becca.
Oh,
We had
hey,
a couple questions.
Okay.
well, Nicole mentioned that was the district autism specialist during the case that you were previously discussing. And
Okay.
she said she can provide any insight if anyone needs. And then Paige Hale asked, does this apply to model lab at EKU?
So model laboratory school, there has been no case determining that. As far as I know, making a decision about whether model is a post-secondary institution, some of the statutory language around that is going to, the big question is going to be whether it is a public school, whether it is a common school in the language of Kentucky statutes. But little bit different in that, as I understand it, the model laboratory school provides elementary and secondary education where Gatton and Craft do not. So it would make it a lot more likely, in my opinion, that it would apply, that the IDA would apply, because those are expressly elementary and secondary school students, while Gatton and Craft are statutorily explicitly post-secondary programs. So that, I think that's the way that would be analyzed. I don't know where that would land, but I think that would be the same analysis they did here. What's the nature of the institution? Is it a post-secondary that happens to have duly enrolled students, or is it an elementary and secondary institution? So I think that's the way that would be analyzed.
And that applies to this next question about how this would work out with dual credit classes housed within a high school. And it sounds like you addressed that as well. So thank you.
I think that's the way that's going to be evaluated. Now, keep in mind that this case right here is on appeal in front of the Sixth Circuit. So what that means is that we don't yet know what the final ruling on this is going to be. We know that it's continuing to be challenged. It's possible that the Sixth Circuit Court of Appeals will decide that essentially that the Exceptional Children's Appeals Board, that the Due Process Hearing Officer, that the United States District Court all got it wrong. That could happen. Or it could be that the Sixth Circuit will look at this and will not necessarily defer to the earlier decision making, but will find that this opinion that I've got on the screen here is well reasoned, is an appropriate application of the intersection between these two bodies of law, and they won't disturb it. Now, if that happens, the parent would have the opportunity to attempt to appeal that to the United States Supreme Court and ask them to grant a particular, they call it a writ, but essentially try to talk the United States Supreme Court into addressing this and figuring out if the Sixth Circuit got it wrong. That would take a couple of years. Whether the answer is yes, they'll look at it, or no, they won't. So this is what we know about this right now. Candidly, probably won't know for sure for 2-3 more years that this one's going to be completely wrapped up and we'll have something that you can really rely on. And it looks like we have another hand.
Yeah, go ahead, Nicole.
Well, and I love that David's addressing this one. I think the major thing with this too, with the parents during the time, was that this student was actually enrolled in dual credit through like a JCPS school through University of Louisville. The parents chose for the craft experience. And so I don't know if that played into it at all too, of why the favor was in the rule of the school district, is that the dual credit program that he attended at Craft was actually being offered within the district, where special education services could have been provided, because there was a period a day where he was attending social skills instruction and actually had some services during those dual enrollment U of L classes.
Yeah, I think that, thank you for bringing that up. A lot of these cases are very fact sensitive, so it's difficult to tell which of these facts courts may seize on in ruling either for a protesting parent or student or for the district. But once things have kind of trickled up or bubbled up to the level where this one now sits, these are largely going to be questions of law. So the farther up the chain you get of reviewing courts, the less likely it is, usually, there are exceptions, but usually the less likely it is they're going to try to really sift through specific facts, and the more likely it is they're going to say, what's Kentucky's statute on this, and what does that mean? Or what do those mean? And what does the IDEA mean at that intersection. So I think that's a great point. A lot of times, very fine factual distinctions can really tip it one way or the other at a trial court level. Often the higher they get up, the less they tend to focus on the facts and the more, does this law make sense? Is this what this law was intended to do? Who was it designed to protect? So, yeah, great point.
I think
Okay.
Savannah had just a sort of clarifying question that's sort of in this same thread.
Okay.
When providing accommodations to students in dual credit classes,
Uh-huh.
are we bound by their IEP or by the accommodations typically provided by the college through which the course is offered?
I can't really address that for you because I think that that would be one where you would have to scrutinize exactly what provisions the IEP had made for particular types of services. You also get into this, transition area about who has to attend an ARC. Do they have the ability to, you got your community folks in there. You got people who may be responsible for either providing or paying for post-secondary stuff. So I can't really give you an answer to it. That's going to be awfully fact specific. So, okay. Okay, I'll move on to the next one here. We do still have one hand up, I think. I don't know if that's inadvertent or not. Okay, I'll click onto the next one here. So the next one, this is a letter to Baruki. That's how I'm pronouncing it anyway. I hope that's right. Letters are issued by the Office of Special Education Programs. You all may know this, but I'll say it anyhow. They issue letters in response to particular inquiries that they get from, sometimes it's a parent, sometimes it is an advocate, sometimes it's a lawyer, sometimes it's a nationally prominent trainer, speaker, TA provider, something like that. But essentially, folks will write to OSEP and pose a particular fact pattern and say, hey, how does the law apply here? How ought we to handle this? And then OSEP, maybe they pick and choose, maybe they just go kind of slow, but usually 2-3 years later, they'll issue some response to that. And they will recite in there, here's what you asked me, and here's what my answer is. So on this one, this letter to Baruki, someone writes in and it basically says, we've got a student who's just not cooperating in terms of not belligerent, not fighting with us, not an unpleasant student, but just simply will not participate in any of the services that are laid out in the IEP. We're doing everything we're supposed to do on our side. He isn't doing anything. It seems like it's kind of wasting everybody's time. Is it okay in light of the student frustrating the purposes of the IEP if we pull back? That's essentially what they asked OSEP. OSEP writes back and says, what everybody knows, you got to provide special ed and related services in accordance with the IEP. They say, well, there's a little bit of wiggle room here. There's not a particular accountability if the student does not achieve the kind of growth projected for the student if the IEP is implemented. So, there's a little bit of a safe harbor if you're one of the implementers. But they also say, but the IDEA applies equally. The district's obligation apply equally whether you've got a cooperative student or an uncooperative student. So if the child's not wanting to participate, that doesn't strip the child of their IDEA right to a FAPE. And then, unfortunately, for the person who asked the question, OSEP then goes on to say, and furthermore, not only can you not stop doing what you're doing, you probably need to take a look. If the child isn't cooperating, you probably need to take a look at, well, is that an indication that we need that we need a reeval? Do we need to revise the IEP? Do we need to change placements? In any event, OSEP says probably need to convene an ARC and try to figure out sort of what's going on with the child. So this is one of these, be careful about what you ask, because the district, the question came in good faith. Hey, it doesn't look like this is working out. Can we quit? And the answer back was, in part, not only can you not quit, you kind of need to redouble the efforts that you're making to be sure that you're responsive to what the child's actual needs are. So yeah, that's that one there. Any questions on that one? Okay, great. Next one here, letter to, again, my pronunciation, I'm guessing, I'm going to go with Ig. So this is a child who's never, it's a Maryland case, like on the border of Maryland and the District of Columbia. This particular case, child's never attended school in the Maryland district. Child has always attended a private school in the District of Columbia. Parent goes to the school, to the district of residence, where she's always lived, with the child, but where the child has never attended, and says essentially, hey, I'd like to have my child evaluated. And the district responds and says, no, that's not our child. That's not our student. Even though he's resident here, in fact, the student has always attended this private placement that you have selected for him in the District of Columbia. So you need to go over there and talk to them about that. In responding to the letter inquiring about the appropriateness of this, OSEP comes back and says, you can't get out of it. If you've got, because of the way that the child find obligation is structured, if a parent of a child who would be eligible for services in your district, if they come to you and make a request for evaluation, you've got to respond to that, even if it happens that the kid's actually being educated someplace else. Now, how's this one going to trickle down, say, here? In Kentucky, we've now got kind of, I'll say kind of porous borders between districts here in terms of what do you do if a parent elects to place, they have their child educated, not in your district, but in a contiguous district. And then one day they come to your district, hey, I'd like to have them evaluated. I think what this probably means is that based on your child find obligation for kids who reside in your district, you probably have to go that way. This is what this would instruct you to do anyway. But that's the way that would be evaluated. Hey, is this a child for whom we would have educational responsibility based on residence as opposed to based on where's the child actually attend? So that's where I think this one goes. Okay, we've got a question, I assume, on the previous slide, so I'll back up.
Yeah, go ahead, Harper.
Yeah, I just have a question as it relates to the private school. So I think I have a good understanding of what you're saying, but just, is there a responsibility to the district in which the private school exists? So I will get a request from the private school and ask for their information so that I can put that student in the Infinite Campus and have access to that student. But then I find that student lives in another district. So should we be conducting that evaluation and then reaching out to the district of residence if it seems like the student may qualify for services, so we can coordinate that? Or should I be reaching out to the district to say, hey, it's your responsibility to complete this evaluation?
So I think we're kind of up against this thing where I can't really give you legal advice. What I can tell you, and I'm glad you asked this question because it's a point that's kind of buried in this that I did not mention. It's actually kind of a dual obligation in this one, in this letter to Ig, because part of the reasoning there was the mom could have gone to the district of residence, which she tried to do, but she also could have gone to the district where the private school was. She could have gone to either one of those, but what you could not do, I think it says, what you could not do is say, as the district of residence, no, you're in the wrong place. It's kind of like the parent gets the choice about whether to go to either one or both. But the obligation of the educating districts is to make some kind of appropriate response to the request for evaluation. So that's probably as far as I can go in trying to answer your question, because I don't want to get into this thing where I'm telling you, oh yeah, here's what you ought to do, because I'm going to get myself crossways if I give you too much advice on that. But that's kind of the way that would get evaluated. I hope that's helpful. I know it's not really responsive, but
thank you.
Any other questions on this one? Okay, great. I'll move on to the next slide we got here. So this is a letter to Riley. I try to set the stage for this one a little bit. So the United States Supreme Court, here's a case, I think it's in 2005, and I never know how to pronounce anything. I'm going to pronounce it Schaefer versus West. I think that's how it's supposed to be pronounced. West, I can understand the spelling of. Schaefer, I'm less certain. Anyway, that case is about, hey, who's got the burden of proof in a due process case? How are we supposed to resolve those if we're either, an independent hearing officer at the state level, if we're a federal district court reviewing that work, who has the burden of proof in a due process case? And in Schaefer versus West, the United States Supreme Court says the burden of proof falls on whoever is making the complaint. So if the parent is the one who's filed the due process complaint, they've got the burden of producing evidence sufficient to take the thing forward. Or if it's a case where the district has initiated a due process complaint, the district bears the burden of proof to move that forward. So that's the United States Supreme Court in the Schaefer versus West case around 2005. Well, letter to Riley comes into OSEP. Well, what about state complaint procedures? You didn't talk about that. What's the burden of proof there? Well, OSEP in responding to that letter and answering that question says, well, it's different. Now, the Supreme Court hadn't talked about it, but so OSEP's kind of filling in a little bit of a gap here. But they're saying, OSEP in this letter says, let's think about the purposes of these two things. Due process, a due process complaint, not the due process folder, but a due process complaint, is essentially like a miniature version of litigation. You've got lawyers, you've got discovery. It's more like a trial. It's more technical, formal, indistinguishable from a regular civil action. But, says OSEP, the state complaint proceeding's really a completely different matter. It's a completely different beast. A state complaint procedure is not supposed to be adversarial. It's a lot less formal. You typically don't have lawyers involved in it. Maybe the district does, maybe the parent does. It's fine if they do, but the process itself is not adversarial. So they say if you think about it through that lens, since it's a non-adversarial proceeding, it's not the complainant's burden to produce evidence, to persuade the finder of fact. It's not the district's, let's say it's a parent. So the parent doesn't have to produce evidence saying, hey, I got this right, nor does the district have to produce evidence saying, no, the parent's wrong, we're okay, we did everything correctly. Instead, says OSEP, the way this is supposed to work is the state educational agency, the SEA here, has to independently take a look at this, independently review the evidence, weigh the evidence, figure out what evidence they want to look at, what they think is relevant, and then make a determination supported by relevant facts. So the answer is neither party has to persuade. Actually, they just have to kind of signal, hey, we think there's a conflict, and then the SEA may about what information they need to get this done. So how much evidence or information does the SEA need to make a finding one way or the other? Well, OSEP says, well, the IDEA is silent on this, says OSEP. It's really not in there, but we think at OSEP that the appropriate standard of proof in this is a preponderance of evidence standard, which essentially means that something is more likely than not. And they say, well, that makes sense to us because that's the same burden of proof that you have in a civil case. You're in a car wreck, you have to sue somebody, whatever. Again, that's just more likely than not. So OSEP says, yeah, we think that's probably the right way. That's the right balance to strike. Does the SEA think it's more likely than not that this occurred? So that's kind of where they had landed on that one. Any questions on letter to Riley? Okay, great. Check my time here. Okay. This next one, as you can tell from the title, it's a Dear Colleague letter about virtual schools. Dear Colleague letters are a little bit different than letter to. Dear Colleague letters, you can think about them as kind of being initiated by OSEP, by the Office of Special Education Programs, not in response to any particular inquiry, but because they are detecting a theme and kind of what's going on in education. Maybe they're getting a lot of TA calls. Maybe they're getting a lot of inquiries from parents, from districts, from advocates, from legislators that say, here's an area of the law, here's an area of application of the IDEA. Nobody seems to know what this means. How can we address that? How can we get the same information out to a number of different constituencies at the same time? The answer can be the Dear Colleague letter. So it's not a letter back to some particular person saying, hey, thanks for writing. Here's what you asked me. Here's what we're saying. It's more, hey, colleague, everybody who's affected by this, here's what the law is around this. Here's the way that OSEP interprets that. So that's what this one was. This one has kind of gotten refreshed a little bit. This is not, you'd think with COVID and all this other kind of stuff going on that this would be really new. It's not. This one's actually, I think, around 2017. But around that time, even pre-COVID, if we can remember such a time, there was already kind of a movement toward virtual programming, at least in some settings. It wasn't nearly as broad as it's gotten to be, in later years. But even at that time, districts that either were being very innovative or because of resource limitations, kids in unusual spots in terms of whether they could come in, home hospital type students, what have you, that there was already at that time kind of a move toward virtual programming, not everywhere, but in different parts of, different districts across the country. So there's a little bit of movement on that, which of course was incredibly accelerated when we got into COVID, when we got into all that mess. So they had issued this Dear Colleague letter essentially to say, how does that fit? How does the IDEA apply in a virtual school setting? Well, they start off by saying, well, if a virtual school, and they're careful here to talk about virtual charter schools, that's contained in this letter. We don't have them, so I didn't talk about it here. But essentially, they say that if a virtual school is a public school of an LEA, and all of our LEAs are public schools, so you'd be hard-pressed to say, oh, yeah, we're a public school except for this. But they say if it's a public school, like, one of your other elementaries, middles, whatever, then the LEA, the local education agency, has to ensure, like they do for every other school, that you're meeting all the requirements of Part B of the IDEA. To the extent that you've got students with disabilities, the LEAs got the same duties to that child as they would for a child attending a brick and mortar school. So that's kind of where they start. So they go on to say, well, to be more explicit, they say, so what we mean there is that the LEA has got to have a plan in place for addressing in a virtual setting, monitoring noncompliance, correcting any noncompliance that you maybe as a DOS become aware of or, that bubbles up. You do not have any slackening or loosening of requirements for the timely collection and reporting of data just because a kid's a virtual kid or just because it's a virtual school. You've got to maintain, you got to establish first of all, and then you've got to maintain any personnel qualifications that are required by the IDEA. So that's, you don't get any relief on that. That's not slackened or diminished in any way. You still have to make dispute resolution processes available. So that whole panoply of or group of things that that are available to dissatisfied parents or other folks, formal complaint procedure, due process proceedings, all that stuff, all that's got to be made available. And that's to the parent, but also to the district, right? And the confidentiality piece of that. You got to maintain the same confidentiality in a virtual environment that you do in a brick and mortar environment. Doesn't say here that it has to be more strict. There's been a lot of chatter, a lot of weird stuff about, well, what's in the background of a student's, you look around, I'm in my house. What's David got behind him? Is that something that he's not allowed to have in school? How are we supposed to apply that? It doesn't really get into that. This is just essentially making sure it's the same level of confidentiality that you would apply in a regular setting. But it doesn't just begin and end at the LEA. The SEA also has obligations regarding virtual schools. The SEA has to have policies, has to have procedures that ensure, just like everything else that trickles down from, the IDEA via OSEP trickles down to the SEA, trickles down to the LEA, trickles down to the school. Same thing here. Each SEA, each state education agency, has got to have policies and procedures that make sure that all the LEAs and the virtual schools, number one, are keeping up with all the obligations that were in the preceding slide, but even make sure that these kids are participating in state and district-wide assessments. So that's a thing that the SEA has to do. And child find policies were also specifically mentioned here. OSEP suggested that LEA should review in a virtual setting, should review both the state's child find policies and their own implementing policies and procedures to be sure that child find is being appropriately exercised for virtual school kids. One thing that they did talk about here, go back to that slide. One thing they did talk about here is they did explicitly say that it is inappropriate for a school to rely on a parent to essentially make the referral. It creates kind of a tough situation for districts because imagine you've got a student who participates exclusively virtually, right? It's a virtual school kid. You may not have a classroom teacher present in the home. Let's say for whatever reason, it's a child where they're not getting visits or what have you. All the instructions happening virtually, the school essentially has no physical presence, no actual regular interaction with the kid. Even in that situation, says OSEP, the school can't rely on the parent to essentially put their hand up and suggest, hey, maybe my child's got a qualifying disability. The school's got to have some way through the way that you provide instruction to monitor what's going on with the kid academically and otherwise, to be able to detect that and make the same type of referral that you would if you were, down the hallway in a regular brick and mortar setting. So that's kind of where they landed on that one. But they did take some time to talk about that particular issue, that, recognizing that that's going to be difficult for schools, that may not be as clear cut as if you had a kid walking down the hallway. Essentially, it doesn't matter. They're not going to let you up off the mat just because there's some challenges in it. Their expectation is that you have some way of exercising child find that is sufficient to catch who you need to catch. Any questions on that one? We got some stuff in the chat. I'm gonna bear with me. I'm gonna pivot over to that and see if there's anything I need to.
Looks like there's just lots of really good conversations kind of happening in the chat. And this is
Okay.
the awesome thing about this group is they help each other answer questions, which is wonderful.
Okay.
Some questions around first steps specifically, but again, it looks like they're kind of supporting each other and have some good thoughts and ideas.
Okay.
So
Cool.
I don't see any questions.
Okay, great. Well, if one happens to pop up and I miss it, somebody just holler at me. So I can catch it because
We will.
okay. Sounds good.
And just as a timestamp, David, it's about 10 minutes till 11.
Okay.
So just as a timestamp.
Gotcha. I'm gonna try not to make anybody dizzy here. Let me check something right quick. Let's go through one more, and then maybe we'll break after that if that suits you. Okay, this next one, the one that I've got on the screen, should be visible to you. Garza v. Lansing School District, Lansing as in Michigan. So this is a Sixth Circuit Court of Appeals case. So it's our circuit. We need to be paying close attention to this because it's the law that would be applied should any of these facts pop up here. And it's a horrendous case. Before I get into the facts on this one, I realized I didn't explain something that I probably should have, and you guys may already know this. When I'm talking about the circuits, here's the way that you might think about this if you ever have to think about the law. So let's imagine, you've got all these different federal circuits, and let's say that a circuit in a federal circuit court in California, the Ninth Circuit Court of Appeals, comes down on an issue. Here's the law that we're going to apply in the Ninth Circuit Court of Appeals. Here's how it is out here. That may or may not be the way that that same law would be applied in Kentucky. So what your lawyers will do, your district attorney, your district's attorney, not district attorney, what your district's attorney will do is, let's say there's some, really important, big headline grabbing kind of case out of the Ninth Circuit Court of Appeals out in California. What your district's school board attorney will do is say, okay, that's what they do out in California or in Oregon or in Washington State. What does our circuit do about that? If the answer is different, right, your attorney is going to tell you, yeah, that's what they do out on the West Coast, but here in your district, here's the way that that law is going to get applied here. So maybe to make it a little bit of a different consumer, if you hear some really huge headline grabbing thing, but it's not from Kentucky or it's not from the Sixth Circuit Court of Appeals, it may or may not be something to worry about. It may be something that's a function of the state laws that they've got in that other circuit, and we don't have the same laws here, so that may or may not disrupt what's going on. So that doesn't mean don't consume any of that, don't pay attention to it. A lot of that tells you, hey, here's what the national trends are. And if the circuits get into it, right? Let's say the Ninth Circuit Court of Appeals and the Sixth Circuit Court of Appeals come to the opposite conclusion about what the IDEA means. Well, that's when the Supreme Court gets involved. Well, we've got what they call a circuit split. The average people, people out in the country don't know what this means. Some courts think it's this, other courts think it's that. Then the Supreme Court will wade in and will resolve what they call the circuit split and say, you guys thought it was this, you guys thought it was that, here's what the actual rule is. So that gets resolved if it's something where they're completely opposite results, but maybe just as consumers of news around education and education litigation, just kind of keep that in the back of your mind. That's the way that your lawyer will be thinking about this stuff. So yeah, bit of a tangent, but it's worth mentioning because you all are interested in this stuff or you wouldn't be attending this. So yeah, just kind of watch for that. Okay, so Garza v. Lansing, this one's a beast. This is a male student with some diagnoses and disabilities that resulted in some degree of a fairly significant emotional disability, a lot of acting out, behavioral problems, acting out, stuff like that, to the point that the student was educated in a series of schools that were essentially segregated out for kids who had really significant disabilities. It becomes apparent to the child's mom that the child is being mistreated at school. The child turns up with bruises, child has stories about this person did this person did that. Mother attempts to file suit against some of the folks in the school, and here it was, the teachers, the principals, the directors of special education, the superintendents. I think she may have even thrown a school board member or two in there, but sues an awful lot of people. Essentially alleging not just violations of the IDEA, but civil rights violations based on the student being physically mistreated. And the federal district court says, we think that they've got immunity. We think that, to the extent that you're trying to sue a supervisor, they didn't really know what was going on, what the teacher had actually done to the child on up the chain. So we're not going to hear it. Sixth Circuit Court of Appeals takes it and they reverse. They essentially say, that's not the rule. The mother should have been permitted to proceed against the teachers, the principals, the director of special education, the superintendent, and so on. And here's where this one gets pretty ugly. Down into the facts of this, what becomes apparent as the Court of Appeals is evaluating this, is the child had been consistently abused over a long period of time, and the administrators to whom it was reported took no action in response to that. For example, they had the teacher who physically abused this child and was finally arrested and charged with 4th-degree assault and permitted to resign, had a habit of several years of not letting children go to the bathroom until they soiled themselves, or if they were at the swimming pool, holding children under the water as punishment for misbehavior, or striking children, or choking children, to the point that, they had aides that would be assigned to this teacher's classroom. A couple of them lasted a day, 2 days, a week. They would make reports to the principal, to the director of special education. You don't know what this guy's doing to these kids. This isn't right. Somebody's got to do something. And over a period of years, the teacher got perfectly fine teacher evaluations. No indication on any formal evaluation done of the teacher that he had ever mistreated anybody. Parents are complaining, oh, my child's got bruises. Hey, he slapped my child. What are you going to do about it? Somebody from one of the local mental health agencies complains, hey, I've got a child who I see in therapy. There's some indication that this teacher is abusing this child. They don't do anything. So no real indication that they're taking any action in evaluation to even document that any of this stuff is happening. At a certain point, the teacher abuses a child, like it may have been this one, I don't recall, and they decide, well, we'll solve that. They move him to a different school. They did not tell the new principal about what was going on. They shredded the principal's notes about the type of behavior that had been reported about this guy that had been investigated, so they didn't take any action there. So you kind of get the picture of what's happened with this guy. And anyway, all this culminates in this assault that resulted. One thing that is important. At one time, the school did decide that they were going to suspend the teacher, but they suspended the teacher really just for investigatory leave and decided, okay, we're going to suspend him for a couple of days. No evidence that they ever did that. Then they decided that they were going to require him to attend some training. No evidence that they ever did that. So the straw that breaks the camel's back is when he gets arrested for physically assaulting this child. They still didn't terminate him, right? The district took no adverse employment action against him, but he did resign. So I guess that's the good news. If you beat children so severely that you're arrested, maybe the police will do something about it. So anyway, the parent, understandably and probably very late in the game, files suit, and the court, the first court, for whatever reason, found that this wasn't foreseeable, that despite all these reports that, who could have known? Sixth Circuit says no. It is clearly foreseeable that a teacher's ongoing abuse of students is going to continue unless that is responded to in some way. That supervisors may not turn a blind eye to misconduct. You cannot say, well, I'm not going to go into Mr. Smith's room because he's in there whipping the kids. No, you've got to make the same intervention that you would for any other teacher. You cannot protect yourself legally by making sure that you don't see what's going on in that particular classroom. Now, they're careful to say here, lest anybody misread this, and it's tricky, right? This doesn't mean that you're responsible for everything that, a sociopathic teacher does. By no means is this strict liability for any supervisor. The recognition here is that you've got to make judgment calls as administrators. Administrators in your buildings now make judgment calls about, we think that's too much, we think that's not enough. All those regular processes are okay, and you do not invite any kind of personal liability in participating in that. You're allowed to make appropriate judgment calls. You're allowed to be wrong. You could do everything right in attempting to, with this particular guy, principal could have documented, yeah, here are the reports that I've got, would have avoided liability. So you've got to almost be an intentionally bad actor to get yourself crossways with a court here. And even as bad as all this was, where this thing landed was the Sixth Circuit says they don't say, hey, the mom's right, school district pay all this money. They just say there's enough here that she can pursue claims against these individual administrators, right? So the role of the court there was not to say, yes, this is so awful, she ought to get money from the principal and the dose and the superintendent. It was just, no, these facts are bad enough. She should be permitted to get this in front of a jury. So try not to, I mean, it's a terrible set of facts, and I don't like going into that much detail, but it's about as bad a set of facts as I've seen in one, right? And I think it's the sort of thing, it's almost hard to imagine how anybody in that supervisory chain could have willfully refused to perform just the basics of their job. And even this, you know, may they end up being personally liable? Don't know. But at least, there's some opportunity for the mother to try to make that case. Okay. So if everybody's comfortable, this may be a good break point for us. We're going to take, I think the schedule has us for a 5-minute break, and then I'll resume here at about 11:08. Does that work out for everybody?
That works for us. Thank you, David.
Sounds great. Thank you.
Okay, thanks.
Hey, David, great content. I'm really glad everybody's hearing this. This is
Oh, thanks.
just good stuff. Once
Good.
everybody comes back, I just want to add just a quick little point to what you just said.
Okay. Yeah, that's perfect.
David, I believe we're at 11:08.
Okay, thanks, Bill. Mike had some comments he wanted to make, I think, before we jump back in. Just kind of had a follow-up thing. If I can defer to him for a second.
Thanks so much, David. That case you described was it was a heavy case, and what I wanted to follow up on, I've seen a lot of things in my career, and one of the things is usually when you get to the point where things are so bad that David was describing, it doesn't happen. You don't just go from zero to this, tragedy. It's many small incremental steps that get to this point where people failed or kind of hid things, or they transferred a person and the receiving principal was maybe young, they didn't want to rock the boat. Sure, I'll take this. So my point is, be very careful as you see these small incremental things build. There comes a point where we all have to have the professional courage to say, hey, this is wrong. It's clearly wrong, and something needs to be done. But then when you get up to a certain point, you kind of get potentially get the institutional pressure against you. Well, hey, I'm in a leadership position and no one else really kind of wants to deal with this. I'm out on my own, kind of an island, which is another, uncomfortable place to be. So my point is to catch these things when they're small before they ever get up to that point, and you'll prevent things like this from ever happening. But it does take professional and personal courage at times. But once you have parents coming to you and other teachers, it's a no-brainer. There's a problem here that has to be addressed. And it's our responsibility to address it. So thanks, David. I just wanted to share that.
Thanks, Mike. Yeah, that's a great point. And one of the other things, I mean, even is a floor that we're all kind of dealing with, right? Kentucky has a very aggressive, I think it's inappropriate, but has a very aggressive statute regarding the responsibility essentially of any adult to report suspected child abuse, neglect, things of that sort. So even completely apart from this, just as a human being out walking around in the world, you've got some expectation of responsiveness to things like that. Yeah, it's a great point, Mike. And one of the things that I hope y'all find, I mean, my dealings with the attorneys who represent districts, yeah, they're expensive. Yeah, they're tough to get to. Yeah, there can be institutional barriers, if you need to put your hand up and get some help and advice. But districts, in my experience, would far rather avoid problems by acting quickly at the first sign of trouble than waiting until something has spiraled so far out of control. Even just from a completely cold-hearted, risk reduction perspective, right? Even taking aside what's the right thing to do. So I think that you'll find that there should be, I think you can anticipate a level of responsiveness from your administration, from your district's lawyer, in terms of how to get into and resolve things like this, should you ever have to deal with something this bad or even not this bad. So, okay, great. Well, somewhat lighter content from here on out. At least to me, it's all relative. Okay, so HC, again, HC, the initials, we talked about that. So this sounds like a terrible case. The parent files a lawsuit. This is a state court case, files a lawsuit against the Fleming County Board of Education, against the superintendent, about, against pretty much everybody the parent could think of. Now, that's not good. Well, this sounds terrible. What did they allege? Oh gosh, everything there is to allege. Well, you didn't provide my child with a FAPE. You discriminated against my child in violation of 504, violated due process rights secured by the state and federal constitutions, retaliated against the student and against the parent when we attempted to call some of this to your attention. You acted negligently. You negligently hired and trained your employees, and you intentionally inflicted emotional distress both on me as the parent and on the student. Well, this sounds horrendous. Well, sometimes you have to count on the courts to sort out what actually happened. The court here says, well, hang on a minute. The board presented through careful documentation and, to Mike's point, contemporaneous record keeping, established that the parent's version of this wasn't exactly the right version of this. That the board presented concrete evidence that, well, the student had been suspended for hitting another child with one of these big, souvenir pencils, and the child had threatened to shoot another student, and that the parent misbehaved so badly that they had actually been banned from school. And that even though the parent had been banned, the parent came to school anyway and started raising Cain, and that's why we had to call the police and file a criminal trespass complaint against her. And yeah, we did have to file a truancy case against the mom, but it's because her other child, who lives in the home with this child, had 22 unexcused absences. So the record keeping that the district here, despite the horror that it sounded like had been presented by the complaint, the board was able to demonstrate factually none of this stuff was really true. And the result of this was that each of the people sued, the teachers, principals, superintendent, board members, everybody wins on immunity at the very front end of the case. Case never makes it to a jury. And it's a consequence, I think, here, number one, of doing the right thing, but number two, of maintaining accurate and contemporaneous records of each one of these things that had happened. So it doesn't mean that people can't say terrible things about you in a court filing, but it means that, at least you hope, and certainly here, courts are pretty readily persuaded, even in the face of horrendous allegations, if you've got a good, strong record of responsiveness to each one of the things that they've complained about. So that's kind of maybe the counterpoint to the horror that was the preceding case. Here's one. It's not really dissimilar allegations in some ways, but lo and behold, none of it really turned out to be true. So that's an interesting one. This next one, I wasn't quite sure how to frame this one, so I've called it tennis tryouts, but let me give you the kind of the floor on this one, or kind of the facts, because these are all stories. So there's a student who had been diagnosed, apparently unbeknownst to the school, or at least not rising to the level of a 504 plan or another formal intervention or response by the school. Child's got some emotional problems. And despite having some emotional problems, the child had participated on the tennis team there at the school, at the high school. It's up in Shelby County. She plays for 3 years, I think it is, plays some matches, has a little bit of trouble getting along with other people, but it's not terrible. Then the district hires a new coach, and things immediately go south. The child has what are described in the depositions as tantrums. She throws rackets, storms off the court. Coach attempts to talk to her. She refuses to hear from him. Mother starts coming to practice to kind of watch, doesn't believe that the coach is acting appropriately. The child doesn't get the playing time that the child and the mother thinks is appropriate. They decide to take the child off the tennis team. Mother ultimately withdraws the child from school to homeschool. They're going to have a tennis banquet. The coach sends apparently a text around, invites everybody on the team except this child to come to the tennis banquet. This child and that child's mother come to the tennis banquet anyway, even though they hadn't been invited. There's a problem there at the tennis banquet. The mother, writes to the superintendent and essentially says, we're having some trouble with this guy. I feel like you're discriminating against my child in violation of 504. Superintendent writes back and says, I didn't know this was a 504 child. There's no evidence that had ever been brought up before, that anybody had ever identified it. Please re-enroll your student. We'll talk about the tennis thing, but most importantly, we need to talk about the 504. Good response. Mother re-enrolls the child. They're in the fall of the year. They have a meeting, but they don't set a 504 plan at that time. But they do get the child re-engaged in school. Child does okay with academics. Get through the fall term. You're getting up into the beginning of the year. Everybody starts thinking about tennis. Gets into January. They convene a meeting. They create a formal 504 plan for the child, but they don't say anything in there about tennis, about how they're going to handle tennis accommodations. And the 504 plan is built pretty much not around any kind of physical disability, but it's built around all the emotional difficulty that this child has, maybe not super well regulated, right? Got a hand up, I think. Somebody have a question?
Oh yeah, so I'm a track coach. I'm a high school track coach. So this resonates with me because I'm not privy to students who when they join a team, we are not privy to any kind of accommodations or anything that they have.
Gotcha.
So
Okay. Thanks for bringing that up. That's good. And they get to a point in this one where that gets to be a bit of an issue. So they have the January meeting. They talk about accommodations they're going to make. They don't mention tennis. They get around to tennis season. They've got the same coach they had from the preceding year. And he decides, hey, I've got too many kids. I'm going to have tryouts this year. Well, that doesn't work out very well for this particular child. They have tryouts. She plays some matches against some other kids. She doesn't make the team. The child's mother says to the principal, I think it is, I think that the tennis coach has discriminated against my child, number one, because of her 504 status, but because they had such a tough time last year, can you do something about this? Principal says, athletic director says, we're going to put her on the team, never mind about the tryout. She can be on there. She can play. She can participate. So they put her on the team. Immediately starts having trouble with the coach again, apparently threatens to kill herself if she doesn't get more playing time. They're continuing to butt heads. It's not going very well. She ultimately is cut from the team after some tryout matches. She's unhappy about playing time, other things, as mother withdraws her from school again, sues. This one ends a little bit differently, and this one ends differently because in deposition testimony, and essentially what happens is they send notice to the school's lawyer, hey, we want to depose, we want to take testimony from the tennis coach under oath outside of court. So they depose him, and in that deposition testimony, he says, we did tryouts, but I already knew I didn't want her on the team because she had acted so badly. She was so poorly regulated. I was worried about her, he says. I was afraid she was going to kill herself. I was afraid, she was going to injure herself, somebody else. I was worried about her, but acknowledges, I didn't really intend to put her on the team. Court says, well, a couple of things. One, he had already decided he wasn't going to put her on the team, so that's a problem. But the court also says each one of these behaviors that the coach was worried about, complained about, talked about, those could have all been directly attributed to her Asperger's syndrome disorder and to her anxiety disorder. If you go back and look at the 504 meeting notes that they had from the formal meeting in January, it's clear from those that the school knew child doesn't respond well to feedback, has very strong emotional responses, fixates on certain people, like the tennis coach that she couldn't get along with, fixates on certain events, like the lack of playing time. So essentially, that it was clear that these were anticipated reactions out of this particular kid. And they say, he probably may have been genuinely concerned about the student, genuinely concerned about her mental health. But the inferences that you can draw from the record in the case are that he excluded her, because of these manifestations of her disabilities, and that because that appeared to be the basis for her actions there, because she would have been otherwise qualified to play, maybe not an all-star, but had participated for 3 years. That a reasonable juror in this case could find that they had discriminated against her. So this one is allowed to go forward. So that's kind of where that one landed. So I think, one of the takeaways here probably is that, kind of that manifestation determination issue. It's kind of, what does the school know? Maybe not the coach, but what does the school know about the child's emotional ability, difficulties, what have you, and how is that addressed? Maybe one of the errors here was to the point or the question that I had a moment ago. What if, when they first had a 504 meeting back in the fall when the child first re-enrolled and they knew she played tennis, why didn't they talk about tennis then? Or when they did the 504 plan in January, knowing that she had been encouraged to participate, would that have cured it? Probably so, because then the tennis coach would have had some notice. They could have, maybe could have responded a little bit differently. So that's that one. This next one, it's Independent School District number 283 versus EMDH. We talked about the initial piece of this. This is about twice exceptional students, and this is a pretty sad one here. Not as bad as the other, I guess, in some ways, but it's pretty rough too. So this child starts having significant psychiatric problems when she's 4. A little tiny child, and starts, having some pretty significant psychiatric problems, a lot of anxiety, may or may not have had some thought disorder, but a very troubled child who's actively in counseling. By the time she's in 2nd grade, she's seeing therapists and psychiatrists on pretty much a weekly basis. Has a series of psychiatric hospitalizations starting, like I said, at 4, 2nd grade, very prominent. Hardly ever comes to school, rarely can because of psychiatric hospitalizations. And unfortunately, what happens is the child, the school will note that the child's having a lot of, the record shows, the school is aware that the child has a lot of emotional problems, a lot of psychiatric problems, not a violent child, not an angry child, not hurting anybody, but just, not doing well, to the point that she's making failing grades. But what the school does is, rather than address that, rather than triggering any kind of evaluation to determine whether she's a child with a disability, they disenroll the child. And that doesn't just happen once. It happens for the first time when the child's, I think, in elementary school, but then for years. This is the pattern with this child. She'll go to a psychiatric hospital, she'll do okay, she'll leave the psychiatric hospital, she'll come to school, she'll be doing poorly at the school. The school will say to the parents, she's not doing very well, we don't want to fail her, we'll just disenroll her. Happens 3, 4, 5 times over a period of 4 to 5 years. So where does the twice exceptional come from? Well, it comes from this. While the child is in psychiatric hospitals, the child participates in educational services provided by those facilities, and lo and behold, is a very bright child, above average, far above average intellectually, academically. And when she does attend school, it's rare, but when she's in school, really does awfully, awfully well, but is so infrequently at school because of absences caused by her disability that she's not really able to make much of a toehold there. The parents talk to the school, hey, we think that maybe she's a student with a disability. School's response is to say, well, we can evaluate her, but if it turns out that she's got a disability, she can't be in any of her gifted classes. So the parents withdraw. Oh no, we don't want that to happen. Well, this happens 2-3 times. The parents struggle, well, she does really pretty well when she's hospitalized. She comes back here, when she's here, she does okay. Can't we evaluate her? School says, well, we can evaluate her, but if you do, she can't be in the gifted program. So this happens over and over and over again. Finally, the parents decide it's worth it. We're going to risk the gifted education. Go ahead and evaluate her. They do. School determines as part of that, she's not eligible for special education. The school's determination as part of the evaluation is that the child essentially just makes bad decisions. It's not that the child is disabled. The school's perception and approach in the litigation is to say, oh no, she's not disabled. She won't mind. She won't behave. So that's not our problem. It's the child's problem. What do you want us to do? The court doesn't take kindly to this. The court, in reviewing all of the records available, says the child's absences here aren't because the child's making bad behavioral choices for which there would not be any IDEA remedy. It is clearly and obviously because these are artifacts of the child's compromised mental health, which disability has been established after the parents go out and get an IAE and all this other kind of stuff. District says, well, hang on a minute, you can't fault us here. She's got really high standardized test scores. And, you look at how well she did when she did come to school, we can't do anything for her. And this is a powerful line. The court says the district confuses intellect for an education. Court explains, the IDEA, it's intended to ensure that children with disabilities get a free, appropriate public education, no matter their innate intelligence. You cannot disqualify a child from participating in special education only because of how bright they happen to be. They knew, that the court says, they knew for years that this child had mental health issues that directly impacted her ability to attend school. They did not make any kind of referral for her based on her intellectual disability. And they stuck with that until the parents finally insisted on this evaluation at the end of the child's sophomore year. Now think about that. 10th grade is how long it took to take some action on this when the child had been exhibiting this same pattern from the age of 4. Okay. So it's a child find case at bottom, right? Their child find obligation is not suspended, is not foreclosed by how smart this child actually is. It turned out one of the things and one of the facts that the court really attended to here, the child had accumulated very few credits toward graduation by the sophomore year, had accumulated all of those credits while in psychiatric hospitals. Essentially received no services whatsoever, no educational services, no education while actually in the district. That particular one cost the district a $25,000 reimbursement for evaluations obtained by the parents in addition to comp ed and other awards. So that was an expensive one, more expensive for the kid, but yeah. This next one, this is a tough one. MP versus Parkland School District. This is not Parkland in Florida. This is Parkland from up in the Northeast. I think maybe a Pennsylvania school district. Here's why this one is tough. This is a student, it's a female student who has very significant, very severe, you might even say profound intellectual and physical disabilities. The child suffers from something called Rett syndrome that is described in a lot of detail and forecloses her ability essentially to communicate, to attend to a lot of external stimuli. Child just has an awful time, a very high needs student. The district does, and I'm not making this up, the district does an incredible job working with this child. Child ends up in the custody of a grandparent. The child's intermittently on homeschooling at the request of the grandmother. School makes Herculean efforts to try to re-engage the grandmother. Please let her come back to school. We've got all these services. They are constantly evolving. IEP provisions, speech and language efforts, anything that the school could think of to try to improve the services for this child, they did. And not just, during one ARC, over the entire time that they're educating this child. They not only do the outreach, at one point there's a dispute about whether the grandmother can understand documents because the grandmother who has custody asserts that she does not speak English, even though she had spoken English in some of the meetings. They arrange for translators, they translate documents. I mean, they do everything you can think of. It's a textbook, wow, look how well this district is doing. Until, and the until is this. She, the grandmother, asked for an independent education evaluation. Doesn't really make any sense. There's really not much that they could do to this, that they could change. So the request, I'm not saying it's made in bad faith, but in light of everything that they've done for this kid, it's pretty benign. You can't make sense of it, but she asked for it. And, as the slide points out, if she disagrees, if the parent, and she's the parent legally, if she disagrees with the evaluation, she can ask for an IE. So what are your choices if they ask for an IE? Well, you've got to either file a due process case, right, against the parent, which is tricky, but that's the remedy that you have. But you can file that to prove that your evaluation is appropriate, or you can pay for the one that they want done. And essentially you're going to be on the hook for that unless you can prove that the one that they did was not up to standard. But what they can't do is they can't sit on that request. And after year and all this effort and all of this money and all of these services, for some reason, when the district got this IE, they didn't do either one. They didn't go ahead and file due process. They didn't respond to the IE request timely. And they didn't pay for it. They just kind of sat on their hands, apparently made some effort to dissuade the grandparent, from pursuing this. So what ends up happening is, after doing everything the record seems to show, after doing absolutely everything in terms of this child and in terms of dealing with his family, by failing to timely respond, to immediately respond to the evaluation request, the district ends up losing the case, right? And because they have lost on an IDEA issue, ends up having to pay attorney's fees to the grandmother. So that's one it's not tragic, but it's unfortunate, but really instructive, because what I think it shows you is you can do everything beyond right, but you can't quit doing stuff right despite a record of success like that. And it's one where you I did kind of felt bad for everybody. The child obviously is in a really tough spot. The district had clearly made unbelievable efforts to try to satisfy that. The grandmother, maybe it's in good faith, maybe it's not, makes this request, and only because of that one mistake, now the district loses the suit. They're on the hook for attorney's fees. It's a mess. So that's a tough one, but part of it. Do a little time check here. I'm going to have to speed up if I'm going to get through these. We're down to the last couple. TH versus DeKalb County School District. This is a class action lawsuit that is filed in the state of Georgia. This one is still kind of being fought out, and the implications of this trying to be determined. The issue is during the hottest part of the COVID response, a sheriff who under Georgia law was responsible for administering a jail in Georgia did not permit school officials to have any kind of access to kids that she had detained in the jail for which she was responsible under state law, and did not independently make any kind of provision or arrangement for the education of those kids, to essentially to make sure that she was supplying all the IEP services or to address IEP services. So this one wasn't so much child find, this was more, did you do what already was in the IEP? In looking at this class action lawsuit, the federal court in Georgia, this was, I think it ended up being litigated in Atlanta, but essentially says, you know, the IDEA applies to state education agencies, to local education agencies, and it also applies to state and juvenile and adult correctional facilities. So if you look, the court says, if you look at the language of the IDEA, it clearly expects that there is going to be a provision of FAPE to incarcerated children who have a disability. Now, there are exceptions to that. There are legitimate correctional needs that can blunt that can interrupt that. There's a whole body of law around that. But here, there wasn't any effort to address it whatsoever. You know, the sheriff makes the point, well, you know, we didn't really have a state law that explained what I was supposed to be doing on this. Court's not really persuaded by that. They say, you know, it's really a very clear case. The IDEA contemplates the provision of these services. So the sheriff loses. But it's not only the sheriff who loses this one. This one's still going on. As of last report, a few months ago, the sheriff was on the hook for $500,000 in attorney's fees to counsel for the incarcerated students. The Georgia Department of Education had already paid $400,000 in attorney's fees to these attorneys. The local school district had paid $75,000 in attorney's fees, and they had not yet finished calculating damages. Attorney's fees that the court finally decided were reasonable in this one were $500 an hour. And the district and the State Department of Education only got off as light as they did because they settled early. So this $499 here, and there was another $38,000 in costs that were assessed. This is still adding up as we speak. The original ask was for $1.2 million in attorney's fees. It's still accumulating now. So there's no telling what this is going to end up costing. But, you know, Central Kentucky is not Atlanta, but $500 an hour being a reasonable attorney fee, that adds up pretty quick. So, yeah, this is not, you get into real money pretty quickly on these things. The last one that I've got, this is a lawsuit filed by a dissatisfied parent about the certification of the special education teacher who provided services under a child's IEP. This is, I think it was in Louisiana. And it was a request for a plea for money damages, essentially for compensation because the child services had not been provided by a fully certified special education teacher. And the court disposed of this one pretty quickly by saying, if you just look at the plain language of the IDEA, the IDEA says that it does not create a cause of action, a right to sue, on behalf of an individual student because of a failure to meet certification requirements. There are other remedies that apply there. The IDEA is not the right vehicle or tool to use for that. So parent, you're out of luck on that. So that's how that one wrapped up. Okay, that's all the slide content that I had for you. I'm not sure, having not been here before, I'm not sure how you all need to proceed, but I'll stop sharing at this point, and I guess I'll kind of listen along with everybody else and see what next steps are.
Sounds great, David. Thank you so much for that information. I was able to look at the chat while you were going. I didn't really see any new questions or anything posed. But again, friends, if you feel like there's something that you want to pose or share, then do that. We will have a few minutes here for some small group discussion. And you guys, am I sharing my screen? I'm not, am I? Hang on. I just realized that. Give me a second. We will have some small group discussion time for you guys to just, think out loud together with these. This was a lot to digest and think about. And again, there was some really good information being shared in the chat and the conversations in the chat. But we do want to give you guys some breakout time. We'll have a few minutes for that. If you don't mind, go ahead and take a screenshot of your small group discussion questions, because you guys know when we switch over to small group, you lose the slide. So if you don't mind, either grab like I said, a screenshot, take a picture with your camera so that when you're in your small groups, you'll kind of know those questions. I mean, these are sort of our uniform questions here. And Becca, will you be putting us into small groups?
Yes, I'll open those now. And I also wanted to remind you that the conversation can also be continued on our discussion board. I shared the link to that in the chat. And Mike, did you have your hand raised to
I
share
sure did.
something?
Yeah, just a quick thought. Hey, I just wanted to encourage everyone. Once you get your jobs as DOSes, or those of you that are in there now, I was very reluctant when I first got hired on to reach out to my attorney. It was just, it was my first kind of go around. And I want to encourage you all to really build those relationships quickly. Once you're in district in those positions of leadership, you need to share with your superintendent the reason you need to have a dialogue or a line of communication with the attorney when you need it. So every district's going to be a little different with the protocols, large versus small district. But I encourage you to ask those kind of questions early, because you need to have sounding boards. And it took me a little while to realize I needed to have a professional attorney as a sounding board too. Thanks.
Great, thank you. I'm going to open those rooms now. We'll have about 10 minutes in each room, and I'll see you back here shortly.
Thanks, Becca.